Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us every Thursday morning. She offers her legal expertise by providing general advice on the latest hot topics. She has experience that spans more than 25 years in the area of property and commercial law. Joining us now to give us some insight today for people buying and selling houses. Good morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning. So yes, this morning it's a super red hot topic because obviously the market is going off. You're a very busy woman. But today we're going to go through the top 10 vital things you probably don't know about buying and selling property. So first up, I have what happens when you are buying an investment property with a tenant.
Yes, so very good point. Very good. First topic to start off with. So when you're buying a property that has a tenant, there's lots of things to be aware of and to consider. One of the things that is often missed is if you're buying a property that has an existing tenant, what normally happens under the standard REIQ contract is that the risk passes to the buyer from the date of contract. So that means that the risk to the property in terms of from an insurance point of view, it passes to the buyer. So the buyer becomes liable and responsible from a risk perspective. So when you're actually buying a property with a tenant, we always say, well, no, the risk should remain with the seller because it's the seller that's put the tenant in there.
Yeah.
It's the seller that has the tenancy agreement with the tenant. Yeah. So the buyer shouldn't take that risk, but it's often missed. So then you need a special condition to put in the contract to say that this risk remains with the seller. If you don't, then it's automatically passed to the buyer. So often missed.
Goodness. So could you just have a tenant in your property as you bought it and you wouldn't, I guess you'd know, but then that's all on you to take
Of
care
course
of.
You'd know about it because it's in the contract, it's disclosed, but then the risk for having that tenant there is yours.
That's insane.
Yeah.
Crazy. Okay, next up, point number 2. Land tax adjustment on residential contracts. What do people need to be aware of with this one?
Okay, so when you buy property, there's always adjustments that you do at settlement. So what does that mean? It means that when you go and pay, you go to settlement and you end up paying the balance to the seller, there's always adjustments that you got to account for, such as rates, water, if it's a unit, body, corporate levies. And land tax is an expense that goes with certain properties. So if you're selling a property, a residential one that's an investment, okay, you might have land tax assessed, right? So the buyer doesn't know that until they do a search, but that's not until you go under contract. So the point here to make is if you are selling a property as a seller and it's an investment and it's residential, so you're not living there as your primary residence, if you have land tax that you've received in the past, under the standard REIQ contract, you cannot adjust for it. There is no allowance to adjust for land tax, which means you cannot recoup part of that land tax expense from the buyer as you can with rates, with water, and with body corporate levies. So if you're wanting to do that, you have to add a special condition in your contract to cater for it, for the seller. So it's really for the benefit of the seller, not the buyer. That you're looking at here.
Yeah, and that's beneficial, obviously, to have a lawyer like yourself.
Yes.
Because people wouldn't pick that up.
No, they wouldn't. And it's just a simple question to ask the seller. Have you ever had land tax assessed? If you have, do you want to account for it and have it an adjustment in the contract? And you cater for it. Yeah.
Yeah, okay. Okay, point number 3. What's the process of changing a buyer's name in Queensland? So not New South Wales, in Queensland.
Yeah, again, this is something that we see almost every day because people don't understand. When you sign a contract and the seller countersigns, you're bound. You've got to get the name right. You then can't say, oh, you know, a week later, geez, I've put the wrong name. It should have been me and my wife, or it should have been in a company or a trust. Let's just cross the name out on the contract and put that name. You go, no.
Doesn't work like that.
Doesn't work like that because you can get charged double stamp duty. Yeah. So make the decision very carefully before you sign that contract. Check with your lawyer and your accountant first. Should it be a company or a trust, or should it be us individually? Because you can't just cross that name out in Queensland. You'd have to then enter into a deed of rescission and do a new contract, which is reliant upon the seller agreeing to that. So always check that before you sign.
Yeah, and would that cost a lot more money going through that
absolutely
fix-up process?
Yes.
Oh.
And it sounds like something really so basic, isn't it? And yet, by the sounds of it, it could be quite easily missed.
easily missed. Easily missed. So people think, oh, I'll just change the name later. No, not in Queensland.
Oh, interesting. Okay, and this one I love because in bold type here in my in my kind of point list, I've got controversial, exclamation mark, exclamation mark. This one is about inclusions and pool cleaning equipment when selling a property.
Yeah.
What? Why?
I know, you think, why is that?
Yeah.
Well, we've just had 2 recent cases. So in your contract, we've talked about this before, inclusions is a big one. What is included as part of the sale? So you've gone and inspected the property, had a look around. Oh, yes, there's pool cleaning equipment, whatever that may be. There might be some pot plants that are included as part of the sale. There could be, you know, security, remote controls, air conditioning equipment, all sorts of things.
Cameras. Yeah, that's a good point.
Yes,
Yeah.
so all of that. So we've had contracts where the agents have drafted it to say in the inclusions, pool cleaning equipment, without any more description. Now that gets a bit controversial because what the seller thinks is pool cleaning equipment, what the buyer thinks is pool cleaning equipment can actually be 2 different things,
So
believe it or not.
you need to be very precise in what exactly is pool cleaning equipment or anything else for that matter.
Well, when you think about it, pool cleaning equipment could be a pool robot machine,
scooper.
Which could
could be a
got
scooper.
thousands or something.
Exactly.
Yeah.
Could be a scooper, could be a hose, could even be the filter, the pump. It could be a whole range of things. And we just recently had a matter settled where after settlement, the buyer said, hang on, where's the pool robot? And the seller said, well, the contract doesn't say pool robot. It says pool cleaning equipment, which is everything else other than the robot. So there you go.
Oh my goodness. And have you had that with other equipment or things around the house as well? Like you mentioned pot plants.
Yes.
I could imagine landscaping, people selling their houses beautiful gardens and little statues. Is that come up often? Do people feel like,
Yes,
is this
it can.
included?
It can. So just because you see it on realestate.com, when you see the pictures online, it doesn't mean that it's included unless it's in that description. But even if it's in the description on realestate.com, my advice is always to say, ask the agent, is this included? Yes, put it in the contract.
Yep.
100%.
Sure, it's in writing. Yeah,
Yes.
good point. Okay, title search.
Yes.
2 words, very simple. But so much can go wrong. Tell me why.
Well, because the title search of the property will disclose what is on that title, what is registered, and a lot of other information about who the owner is, whether there's a mortgage, etc. But what we're looking for is easements, covenants, other things that are registered on title that do not change from the time that you buy and you settle. So if you don't disclose in the contract what is on the title, such as easements, such as encumbrances, which are easements, covenants, other things registered on title that are not going to be removed after you settle, they need to be disclosed. And if they're not, then it's a right of termination for the buyer. So in other words, when you're a seller, you need to have a title search that's current. You need to make sure the contract is actually disclosing what's on title. Otherwise, the buyer could very well have a right to terminate all the way up until settlement, and you don't know that. So it's just about making sure your I's are dotted and T's are crossed.
Yep.
Yeah, and everything in writing.
Yeah, that's it.
Yeah. That is Despina Priala from Priala Legal. More talking law is coming up next. Don't go anywhere.